Understanding employee pay and entitlements. Pay and entitlements differ from one job to the next, so it's important to understand what applies to you and your workplace. Most employers and employees in Australia are covered by the Fair Work system. This system has various parts. Together, these parts set and protect an employee's minimum pay and entitlements.
Think of the Fair Work system like a stack of blocks. First, you have the foundation. This is made up of the National Employment Standards, often called the NES, and the National Minimum Wage. The National Employment Standards are the legal minimum standards that must be provided to all employees. They deal with things like leave entitlements, maximum weekly hours, notice of termination, and redundancy pay. Some NES entitlements don't apply to casual employees. The National Minimum Wage is the minimum pay rate provided by law. It is reviewed by the Fair Work Commission each year.
In most workplaces, this foundation is only a small part of the picture. Most employees have an award or enterprise agreement that applies to their work and provides higher pay and additional entitlements. They provide employees minimum pay rates and usually include entitlements about things like rosters, breaks, shift lengths, penalty rates, and allowances. They can provide additional entitlements that build on the foundation of the NES, like annual leave loading or higher pay for working on a public holiday. But they can't remove or reduce any NES entitlements. The foundation stays firmly in place.
Let's look more closely at awards. Awards are legal documents created by the Fair Work Commission. They set out conditions and entitlements for a particular industry or occupation. There are about 100 different awards. They automatically apply to employers and their employees doing the type of work described in that award. A business might be covered by more than one award depending on the type of work its employees do. For example, Amric runs a lawnmower store and his business also offers gardening services. His store employees are covered by the General Retail Industry Award, but his gardening employees are covered by the Gardening and Landscaping Services Award.
In some workplaces, pay and entitlements come from an enterprise agreement. An enterprise agreement is a legal document negotiated between employers, employees, and their representatives. To be approved by the Fair Work Commission, the conditions in an enterprise agreement must be better off overall than any relevant awards. Once approved, an enterprise agreement replaces any awards or previous agreements that would otherwise apply. Award pay rates, which are usually adjusted each year, continue to underpin an enterprise agreement. This means if an employee's base pay rate would be higher under an award, the award base rate applies. But other entitlements will continue to come from their enterprise agreement. An enterprise agreement allows employers, employees, and their representatives to tailor pay and entitlements to better suit their needs.
Back at Amric's business, Amric and his employees might choose to bargain for an enterprise agreement that covers the work of both store and gardening employees, setting pay and conditions that fit the unique requirements of their workplace. In some cases, there is no award or enterprise agreement to cover an employee's work. This means the employee is award and agreement free. These employees are still supported by the foundation. They get NES entitlements and must be paid at least the national minimum wage.
The final block in the stack is an employment contract. Employment contracts are agreed between an employer and an individual employee, usually in writing. Employment contracts can provide extra entitlements, like higher pay, more leave, or access to benefits, like a phone or company car. They can also set out things like employees' duties, work location, and confidentiality requirements. Importantly, an employment contract can't reduce or remove any entitlements or provide pay rates lower than the minimum set by the other Fair Work system blocks. This is the case even if the employee agrees to it.
If you have questions about pay and entitlements, problems at work, or making an enterprise agreement, there are two agencies in the Fair Work system who can help: the Fair Work Ombudsman and the Fair Work Commission. While they sound similar, they're separate government bodies with different roles.
The Fair Work Ombudsman is the national workplace relations regulator. They provide information, education, and advice to both employers and employees to help everyone understand and comply with workplace laws. They also work with employers and employees to resolve workplace problems and guide them to compliance. Where required, the Fair Work Ombudsman can take action to recover underpayments and enforce compliance.
The Fair Work Commission is the National Workplace Relations Tribunal and Registered Organisations Regulator. They set the national minimum wage, make and vary awards, support enterprise bargaining, approve enterprise agreements, and deal with workplace disputes and issues like sexual harassment, discrimination, workplace rights, bullying, and unfair dismissal.
To learn more about the Fair Work Ombudsman and Fair Work Commission, visit their websites.